Good morning, everyone. We'll start with the second matter. The people of the Virgin Islands versus Cumberbatch, number 47 of 2024. Ready to proceed?
Good morning, Justices, and may it please the Court. Sean Bailey, Assistant Attorney General, for the appellant, the people of the Virgin Islands.
Wish to reserve any time for rebuttal?
Yes, I would respectfully request to reserve 3 minutes for rebuttal.
Very well.
In this matter, the Superior Court erred in suppressing evidence obtained from cell phones in the possession of appellee for 3 primary reasons. First, the facts set forth in the affidavit, together with reasonable common sense inferences readily drawn from those facts, established probable cause to believe that evidence of murder and conspiracy to commit murder would be found on cell phones in appellee's possession. Second, even if those facts and inferences were insufficient to support a finding of probable cause in the first instance, they clearly demonstrate that the VIPD acted in good faith in executing a warrant that they believed, objectively, reasonably believed, was supported by probable cause. Attendant to that, the good faith analysis also requires us to look at deterrence and balanced against the possible cost to the justice system, and in this case, suppression cannot possibly deter future Fourth Amendment violations, and any minimally potentially deterrent effect is certainly outweighed by the price that would be paid by the justice system and the community at large in this murder and conspiracy to commit murder case. And finally, the appellee in this case lacks Fourth Amendment standing to suppress evidence obtained from the other defendant, Sharif Matthews' cell phone in particular. There's also an alternative argument presented in our brief that because there was no contention that there was no probable cause, all parties agree, the court agreed that there was probable cause to believe that some evidence of murder and conspiracy would be found in the apartment and the vehicle. That, for example, the court readily agreed that there was probable cause to search for guns and ammunition.
But that's not an issue, though. You only look at your brief. Look at page 1 of your brief. And, no, look at your notice of appeal. The notice of appeal that you filed on page 1 of the appendix. And this is what you said. The sole issue for the court's consideration in this interlocutory appeal is whether the Superior Court abuses discretion by suppressing evidence obtained from a search of co-defendant Sharif Matthews' cell phone.
Yes.
Yeah, that's the sole issue that you said in your notice of appeal.
Yes, Your Honor. I was only stating the piece about probable cause for guns and ammo to say that once...
But stick to that issue.
Yes.
Because that is the issue really that is before us. And then I noticed that you, and I don't want to say disingenuously, but you expanded on the issues, the statement of the issues on page 1 on your brief. Now, I'll tell you something. I don't like when lawyers put in their notice of appeal one issue, and that is the issue that I am seeking to decide, and then they somehow adroitly craft other issues that seeped into it, okay? So the only issue that I understand that you were seeking is whether or not you would find evidence of a crime in Mr. Sharif's cell phone. Later on, of course, there's a lot of expansion and a lot of things, but that's not what you have in your brief. Remember now, this is an interlocutory appeal. And in an interlocutory appeal, I'm going to hold you to the rule, our rule. And our rule for make it clear that in a notice of appeal, you put the issues for the court and where that issue can be found or issues can be found in the record. I don't like the idea of this expansion of things, but go ahead anyway.
Certainly, Your Honor. I certainly would never wish to be disingenuous with this court. It is still a single issue, which is whether or not, it's just a single issue with sub-issues. The single issue is whether the Superior Court erred in suppressing evidence from the cell phones, particularly
Right.
Sharif Matthews' cell phone.
Tell me in no uncertain terms, very succinctly, what role did that cell phone play in this murder? Now, let me tell you what I understand were the facts of the case so that you can understand what I said. All right. One night, Mr. Benjamin is at home, and two persons later on found out to be the two defendants, Sharif and Cumberbatch. They drove up in a white car, and the female of them, with the limp, went over and peered into the window of the decedent, the deceased, the victim, and she saw him in there. She came back. There were conversation with the gentleman, which was dressed in black, and they had take the car down, hide the car in the bush. The car is a white car, which later on it was traced. I have no problems in terms of the search of the car, because I think that the car would seem to play a vital role in this. I have no problem that shell casing and guns were utilized in the killing of Mr. Benjamin. As a matter of fact, he get 5 shots. By the time he get to the hospital, and about 3 o'clock in the morning time, he expired. He died as a direct result of being shot. Now, I don't have no problems in terms of search warrant for guns, because guns play a vital role in this. And they even have where the gentleman, whoever he was, later on perhaps was Mr. Sharif, utilizing the gun to the extent that making motions of firing shots. But I want to know, what's the nexus? What's the nexus of this crime of murder as to that particular telephone? Now, I know that sometimes telephones, in drug deals and in other things, the telephone become a means of communication and so forth and so on. But unless I read the record, and I read the whole record, I haven't seen in the record where either of them had a cell phone. Did you see that in the record where on the surveillance camera, any one of them had a cell phone?
No, Your Honor, but I would say a few things.
All right, hold on
in
one
response.
second. Is there any evidence that any one of the two alleged co-assailants utilized during the murder a cell phone to communicate with each other, or a cell phone during the murder? Is it in the record here?
Well, Your Honor, critically, it's not just the crime of murder, it's the crime of conspiracy to commit murder, which by definition involves communications between more than one person,
Well,
between two or more
where is the
people.
communication in this record that you talk about?
Do you mean in the affidavit?
That's where's the nexus to this crime with the cell phones? Was there any evidence anywhere that the cell phones were used to plan or to commit the crime?
Well, that is the evidence that is being that the Superior Court suppressed. But if we're talking
Well,
but if
yeah,
we're talking
of
back in
course.
time to where the officers were trying to establish probable cause to believe that evidence would be found on cell phones, then it's not just the facts known to the officer, it's also reasonable inferences drawn from those facts.
What,
Yeah, but
The-
what reasonable
what
inferences
items
are you talking
what
about?
items did the warrant designate to be seized?
The warrant itself, the March 5th warrant, specifically designated a search for firearms, ammunitions, firearm cleaning kits, firearm cartridges, firearm manuals, magazines, holsters, paraphernalia, cell phones, electronic tablets, and clothing. But as to the probable cause, so how do we get
But
from...
let's go to the probable cause.
Yes.
The first item you mentioned is that the facts in the affidavit establish probable cause. Are you saying that the affidavit that was filed days after the warrant had been issued can cure an unconstitutional warrant if it was unconstitutional?
No, Your Honor, I would not say that anything filed later could cure anything unconstitutional, but in this case...
So then why do you say that that established probable cause if it wasn't submitted with your request for the warrant?
That information was relayed by the testimony of Sergeant Jules. She testified that the information that's contained in that, the affidavit that was filed on March 5th is the same as the information that was relayed over the telephone to the magistrate in order to obtain the telephonic search warrant on March 2nd. Now, the facts...
With regard to that document, are you saying that, are you referring to the March 5th, 2021 document?
Yes, Your Honor.
Okay. Where does that document have any fact relating to any cell phone?
It's not just the facts stated that we're looking at to determine probable cause, but also the reasonable inferences drawn from those facts. So the facts that we have here...
Okay, we
first-
understand that argument.
Right,
You're saying that, you know, cell phones are used every day and people use them to communicate with each other and they likely spoke to each other about this crime.
But I would also say it goes beyond just pure generalities. While that is also relevant, it goes beyond that. For example...
But, you know, the defendant make it clear that you're looking for a general warrant.
No, Your Honor, the warrant in case was not general. It specified the things that I just read.
Then I still can't get past what's the nexus, and we don't have to run around Robin Hood's barn.
If I may.
But what do we do with the contemporaneous notes that the magistrate took? And that is the basis on which she granted the warrant. Are we supposed to overlook that and go with the testimony of an officer who was saying what she thought she told the judge?
The notes that we have purportedly from the magistrate did not come from any of the parties. It was brought to the hearing by the court itself. There was no opportunity to examine anyone, to authenticate the evidence. The fact of the matter is we have no idea what the circumstances surrounding the creation of that document were, what the nature of it was, whether it was meant to be an exclusive list of everything relayed over the telephone. Essentially, it's an unreliable
Why should we treat that as
document.
evidence in this case?
Sorry, Your Honor?
Why should we treat that as evidence in this case? We don't know where it came from.
Right. Our position is that It is not the March 2nd private notes of the magistrate that are relevant here, but the only thing we have to go on, which is the official March 5th
Let's-
affidavit and warrant, plus the testimony
So
of the officer who
let's
requested it.
turn to that March 5th, 2021 document then. Where is the probable cause in that document?
Certainly, Your Honor. So we have facts in the affidavit that Appellee possessed and drove a car and rented an apartment at which she sometimes entertained a particular male visitor. The inference there is that Appellee likely had sufficient financial means and motivation to acquire a cell phone, given that she was both mobile and socially active. Now, combine that
my
with the
God.
general
You're not-
knowledge.
If she could afford a cell
you're
phone,
not
that that's
for real,
sufficient?
are you?
I mean,
I mean, every cow tipping, hooting nanny can afford a cell phone these days.
which is,
So having a cell phone means nothing. I see kids, teenagers, they even have those in elementary school now walking around slip-slapping with telephones.
absolutely, Your Honor. But that's simply to get to the inference, the reasonable inference from those facts that
reasonable
Appellee owned a
inference?
cell phone. Yes, Your Honor. I mean, as you point out, I imagine if we...
Who is going to make that reasonable inference?
Anyone who has everyday experience interacting
if
with
you have a reasonable
people in the
inference
world.
to issue a warrant, isn't that the duty and responsibility of the magistrate or the judge to know whether or not she's going to take a reasonable inference?
That's correct, Your Honor. It is the duty of the magistrate to, if she wanted additional facts spelled out, to ask for those facts. That's why the good faith exception exists.
Let me ask you-
problem is-
Well, yeah,
Before, your time has expired, but let me just ask you one question. Wouldn't Ms. Cumberbatch have a reasonable, expectation of privacy for a cell phone that was found in her, that was actually taken from her apartment? Wouldn't that give her sufficient, standing, basically, to contest whatever is contained on that?
No, Your Honor. The fact that someone else's property is located in a vehicle, for example, there's plenty of cases on a
I know,
bag
but this was
belonging to
found in
someone.
her apartment, correct?
On the sofa
this
in
is
her apartment.
not in the car, because you
Certainly.
see, the car was allegedly present at the crime scene during the murder. That's what was hidden behind the bush, and that's what they utilized, and which was traced by public safety. So there's no question as to probable cause involving to search the vehicle that apparently was utilized by whoever was the assailants. But this is a cell phone in somebody's home, and which were not seen on the outside during the commission of the crime.
Okay, thank you. And you have 3 minutes. Hopefully you can address some of these questions.
Thank you, Justice.
Morning.
Hey, please, the court. Jeffrey Moorhead on behalf of the appellee, Tanisha Cumberbatch. Your Honors, two things are quite...
Try to keep the mic in front of you. I know you don't want to. You push it on the side, but you need to speak directly into the mic.
I will.
Okay.
So used to watching TV and politicians adjust the mic. I don't know why I did that. I'll leave it alone. Two things are clear in this case, Your Honor. Number one, this was a general warrant. A general warrant issued by the magistrate that lacked particularity, which is required by the Constitution of the United States, which applies to the Virgin Islands in the Organic Act. Number two, this was not only a fishing expedition by the government, it was a fishing tournament. Cell phones had nothing to do with this case. The word cell phone was never mentioned in any affidavit. Cell phone was never even seen in the videotape that Officer Jules reviewed. This is a fishing expedition, a tournament.
Well,
Let's
which
go
is it,
back.
a fishing expedition or a fishing tournament?
Fishing tournament on steroids, Judge. They have absolutely,
It's a fishing,
I'm trying to be sarcastic.
Yeah.
They have, cell phones has nothing to do with this
right,
case.
okay, but it's a fishing expedition on steroids. All right, okay.
Because it had nothing to do with this case. Officer Jules, after she was put under oath and when she was speaking to the magistrate, never even mentioned the word cell phone or electronic device or computer or anything of that sort. And how do we know? Because the magistrate, pursuant to Rule 401, took contemporaneous notes.
Did you say 401?
I think it's 4-1.
It's 4-1.
4-1, and there's subsections,
Okay, it's 4-1 of our rules. All right.
which requires that a magistrate put the officer under oath, number one, which requires that the magistrate take contemporaneous notes or have it recorded. Another case that came before this court, I think the Superior Court judge taped the conversation. And additionally, it also required, and the magistrate did, submitted the notes right after she took them on the following Monday. The people would have the court believe that the testimony and the memory of Officer Jules 3 months and 3 years after the fact is better than the magistrate's notes that she took contemporaneously. And that's disingenuous.
Well, let me ask you this. Do you have rule -4 in front of you?
No, I don't, Your Honor, but...
All right, okay, but is there a specific section of Rule 4-1 which is titled Warrant or Summons by Telephone or Other Reliable Electronic Means? And they give a procedure, and they're taking a testimony under oath, and it goes through a lengthy thing. Is there any particular section in that, do you recall, that you would reference?
I referenced the entire thing. Some of the requirements are may,
entire thing.
and some are actually required. The magistrate complied with all of them, and she clearly states that she placed Officer Jules under oath, and then she recited what Officer Jules told her. And it's very short. She stated 911 received a call regarding a gunshot in Estate Carlton. Mr. Benjamin Sr. reported that he was shot by a male and a female. EMS picked him up at the Carlton address, took him to the hospital. Dr. Coney stated the victim sustained multiple gunshots. Video footage from the area, it was a DoorDash cam down the road that it was enhanced. I'm just explaining that. That's not what's stated here.
Yeah, I know.
Video footage from the area showed a white TL with rims and a sticker in the back window. It was specific type accurate TL. Excuse me. The vehicle turned around near the victim's house. Seconds after a female walked in, a male followed shortly after, describes in 3/4 length pants, raised his hands and appeared to fire. The TL is not registered to Tanisha Paris. It says Taji Paris. At the address, but that she states she lives at 2 Betsy's Jewel. The owner of number 2 Betsy's Jewel states that Ms. Cumberbatch is a tenant in apartment A and sometimes there with a male. Apartment A was described as a yellow in color bottom floor apartment, and Aisha Jules, the officer, the detective, also received information that Ms. Cumberbatch had previously been involved in a relationship with the victim. That's it.
Yeah, all right.
That's
But
it.
Do you remember who owned that car with connection to this crime? Do you remember who?
Of course I do. It's a sister, allegedly a sister of the co-defendant.
The sister of Mr.
A sister of Ms. Cumberbatch's, sister of the co-defendant, Mr. Matthew's sister.
Yeah, Mr. Matthew. All right, okay. And she was off island at the time.
She was off island at the time.
So he was utilizing the car.
Yes.
All right.
But my point is, the magistrate recited exactly what was told to her and what I just read you. There's no mention of cell phones. None whatsoever. There's no mention that the two of them appeared to be speaking on the cell phone or that they were conspiring on the cell phone, they were waving a cell phone, seen carrying a cell phone, speaking to perhaps a getaway driver by a cell phone. No mention of cell phones whatsoever. So the magistrate never authorized anybody to seize any cell phones. In fact, the warrant was so general, the magistrate just said, just search 2A Betsy's Jewel, period. And that's a general search warrant if I've ever seen one. Based on the foregoing, the undersigned judicial officer granted a search warrant for apartment A and number 2 Betsy's Jewel address, its curtilage, and a TL vehicle. Search for whatever you want. Search for whatever you want. Not just a red notebook, like in John, or a blue notebook like in John, or a copybook. Just search for whatever you want. And any warrant that lacks particularity is a general search warrant that's illegal. And no officer in the right mind could...
Ask you this, attorney. The government make much ado about these inferences that can be drawn. And when you have people making inferences that can be drawn, that is something that just could create chaos, fiasco, and so forth and so on. Is there any inferences that can be drawn for a cell phone remotely in this case?
None in this world. No. No. The
Particularly
cell phone's
when-
not even mentioned. Cell phone doesn't come into the picture until after the police kick down the door, get a search warrant, walk around, and they see a white cell phone by my client's bedstand, her bedroom. If she doesn't have a right to privacy there, where does she have it? And the 2 other cell phones were in the living room. That's the first time cell phones come in the picture. And the government just grabbed them up, collected other things, and left. This was a general search warrant. And since it was a general search warrant, the good faith exception doesn't apply, because no reasonable officer can conclude without particularity that they had a good faith basis in continuing a search that lacked particularity, especially if it's the same officer who told the magistrate what the facts were and never mentioned cell phone. It's similar to like in John, where the petitioner accused the court of being in error with the facts that were relayed to the court by the same petitioner. That's very disingenuous. So the good faith exception doesn't apply because of U.S. versus Leon and People versus
This is not a
John.
case where an officer have a good bona fide warrant to search an apartment in a particular building. They show up, but they inadvertently go to the wrong apartment or the adjacent apartment. Then you would say that, well, you know, there's a good faith here because they get a bona fide warrant, good and everything, and therefore they are, some kind of good faithness should be extended to the officer if they went to the wrong apartment that's adjacent to the apartment designated. But this is not that kind of case.
This is not a bona fide warrant. It's a general warrant. Search apartment 8, number 2 Betsy's Jewel, period. And its curtilage, period. Search it for anything. Your imagination is your limit. That's why I sarcastically state this is a fishing tournament beyond a fishing expedition. Search for whatever you want. If that's the rule of law, we're in big trouble here in the Virgin Islands. And common sense is not a requirement of the Fourth Amendment, but the particularity clause is. And in this warrant, the magistrate fails to say what to search for. Didn't say search for guns, didn't say search for ammunitions, didn't say search for cell phones. Incidentally, we're talking about affidavits, and on March the 2nd, that affidavit was verbal, but it was reduced to writing by the magistrate. On Monday, March the 3rd, Officer Jewell submitted a written affidavit. Nothing in there about cell phones. Nothing in there about electronic devices. Nothing whatsoever. But that affidavit doesn't count. They already had the cell phone. It's the statement under oath that Officer Jules, Detective Jules, gave to the magistrate that counts, because that's how they got the warrant. They kicked the door down and they took whatever they want. And now they want to say common sense and inference. Well, they need a constitutional amendment to put that in there. If that's going to trump the particularity clause of the Fourth Amendment,
But
they need a...
the magistrate did grant a warrant to
Yes.
search the apartment and the vehicle, correct?
I consider it a general warrant.
Okay,
No
so-
limitation.
But with that warrant, wouldn't the officers have good faith belief that the warrant permitted them to search the apartment and the vehicle?
No reasonable officer could have a good faith basis when they look at that because there's no particularity in it, none whatsoever. A good faith on what? What are we supposed to look for? What are we looking for? Nothing. And
You're saying that everything discovered in that search should be suppressed.
everything, because it was a general search warrant, and the good faith exception doesn't apply. And that's what the Supreme Court said in Leon, and that's what this court said in People versus John. Allowing the admission of evidence obtained through a general warrant, no matter how well intended, would eviscerate the fundamental protection afforded in the particularity requirement. Can't say it any clearer than that. So this was a general warrant. Everything should be thrown out. There was no probable cause. There was no nexus between cell phones and the crime in Estate Carlton. None whatsoever. The word cell phone wasn't even mentioned. There was no mention of a white cell phone, a red cell phone, or a gold cell phone. The white cell phone came from my client's bedstand in her bedroom. She had a reasonable expectation of privacy there. Additionally, the phone was in her possession, and the Fourth Amendment speaks to the right to possession as well as other things, speaks to possession. But in any event, when someone executes a general search warrant in my house or your house, there is no law that states that you don't have the right or the standing to challenge it, because it's a general warrant and it's your house.
In other words, it has to be the place to be searched and the thing to be seized with particularity.
None of that was here, Judge. It just said, search number 2, Betsy's Jewel, apartment A. Search it. No limitation, search it. They came back, they picked up clothing, cell phones, some of which were broken, I think a tablet. The list is in the appendix, but they just grabbed what they wanted. And they still couldn't justify it on the Monday. Incidentally,
I gather, Tony, from reading the record, that the government is said, in essence, that down below, I'm not saying they say it here, but in the lower court, they said, well, you know, if we search those phones, we might find something in them that would herald back to this crime. But that's not the Fourth Amendment, of course.
No.
But what they're saying is that, you know, let's, since people don't conduct a lot of business on their phone and on these electronic devices, perhaps if we can grab them, even though nothing about the phone showed up and had anything to do with a crime in this case, at least so far as I can see from the record. But if you search, maybe if we get an opportunity to search the phone, we might be able to get some conversation between the defendants that would lead us to this particular crime. I gather that that's what's
if you keep throwing out the fishing line, you might catch something, Judge.
Huh?
If you keep throwing out your fishing line, even without bait, you might just catch something. Incidentally, there were several warrants in this case that went over a period of 2 weeks, all from different magistrates, incidentally. And one of the magistrates, it was a search warrant to search the Acura TL, which I would admit I have no standing to challenge that. But if you look carefully at the warrant that's in my appendix, the judge crossed out computers and electric devices at the back, and the warrant for the TL. Why? Because there was no basis for it.
That's the magistrate that's now a Superior Court judge.
And that's the magistrate that I just saw this morning, yes.
Yeah, and
He's here in the building.
And he went and painstakingly run a line through that application involving that. That looms large, doesn't it?
It does, especially if you do a lot of criminal law, you will see that the warrants, and you might know this from seeing warrants come before the court, it's a form warrant. And it's in the same order. And it includes everything: clothing, guns, cleaning manuals, gun manuals, and at the bottom, computer, electronic devices. You can't get any broader than that.
I don't want to get too far ahead on this, but you mentioned something. You said that you don't have any quarrel with the car, or you're leaving that for another day.
Well, I don't have no standing. My client has no authority, no standing with the Acura TL. It was just in her driveway. She didn't own it. She never drove it. It was the co-defendant's sister who was our filer.
Acura?
Excuse me? Yeah, Acura TL.
Okay, because they keep saying the TL,
Yeah.
and I was wondering which car is the
No,
TL.
Acura TL is a little smaller than Acura RL. It's a little smaller
all
version.
right. Okay, yeah, okay.
Okay, thank you.
Thank you, Your Honor.
Justice, I'd just like to clarify a couple things. The Acura TL was the vehicle, the Acura TL in Ms. Cumberbatch's driveway was the Acura TL observed in the surveillance footage from the crime scene from the murder. That is what led them back to the apartment to Ms. Cumberbatch and Mr. Matthew.
Oh, I don't think that anybody would have any problems as to whether or not there's a nexus between that, now that I know that Acura TL that was surreptitiously hiding in the bush while things were being conducted to execute Mr. Benjamin.
Secondly, I'd like to correct or challenge at least a few statements of Appellee's counsel here. He said that those notes were taken contemporaneously. We don't know that. We have no testimony to say that. Again, he said the notes were submitted. Submitted to who, when? They were not filed in the matter. In fact, if you look at the copy of the notes, there's
Which
handwriting
notes are you
not
talking
for
about?
release.
Which note are you talking about? Because I get this distinct impression, let me tell you what my understanding is. I get a distinct impression that they call up the magistrate, that is Sergeant Jewel or whatever is her rank, and she was talking with the magistrate judge, and she was giving the magistrate judge information. Later on, there is a little clause in the record that says that she was under oath. I had gotten the distinct impression that she was not under oath, but at least 3 words in the record later on, and maybe in volume 2 or whatever, that says that she was under oath. Was she under oath or not under oath when she gave her statements to the magistrate?
She was under oath. She testified to that effect.
For which warrant? For the first one? The March 5 warrant?
Or yes, that is the only operative warrant in this case, is the March 5th affidavit and warrant. But my point here is I would implore this court not to make the same to make the same conflation that the Superior Court did and that Appellee is here, which is to treat these notes taken by the magistrate at JA 293. It's titled to not conflate this to be a search warrant or an affidavit. These are presumably, and again, we do not know because we have no testimony. The parties did not receive this in discovery. The court, the judge himself obtained this, presumably by going directly to the magistrate. It's titled application for a search warrant, not affidavit. The handwritten note on the bottom is not for release. It does not purport to be a warrant, but some sort of memorialization of the conversation. It doesn't purport to be a complete and verbatim transcript of that conversation. It certainly doesn't appear to be. The only affidavit and warrant that we have to go on in this case are those submitted on March 5th. Now, to the extent that warrant and affidavit was missing anything, it was incumbent on the magistrate that approved that warrant to request it. In this case, what we have is 2 individuals seen on surveillance footage who arrived together in a vehicle at the victim's home, they exit the vehicle and immediately appear to fire shots. Then they get back in the vehicle and leave. That gives probable cause to infer not simply that someone was shot and killed, but that it was premeditated, planned, coordinated. This day and age, as the Supreme Court has reserved, cell phones are so ubiquitous that a visitor from outer space might conclude that they were a part of human anatomy. The statistics are overwhelming. Certainly, to a police officer who has been trained in criminal activity, knows how criminals communicate,
Oh,
how
but
they conspire
I
together,
thought-
she would be able to, sorry, Your Honor.
Attorney, I get the distinct impression that they were going together. They didn't have to have a telephone conversation. Apparently...
During the crime,
he
perhaps
might-
not, Your
he
Honor,
was
but how would they
seeing-
know when to meet up, where to meet up?
Oh, but they didn't have to use a phone for
Your
that.
argument would lead to the conclusion that cell phones are fair game for searches.
Only when there is probable cause to believe that there has been a conspiracy to commit a crime and that the communications involved in that conspiracy would likely have occurred over cell phones, which based on what the officer knew, the undisputed facts stated in the affidavit, there was enough from that to reasonably infer that these parties would likely own cell phones. Alternatively, given that no one challenged the warrant to enter the house to search for guns and ammunitions, I would also like to...
Attorney, I have a problem with what you're saying, because it seems to me that if someone is going to hire a hitman to put a hit on somebody, well, you could, you can infer that there was some conversation between the two of them. But I get the distinct impression that they were more like lovey-dovey. They were going together. He was seen several times by the landlord in her house, and that the two of them were going together. Well, they wouldn't need a telephone to plan anything, particularly if he was living there with her. It doesn't come out in the record that he was living there with her, but he was seen there quite often.
It's not just the communication data, Your Honor, it's also the location
Bailey,
data.
Is it basically the government's position that in every crime, a cell phone is fair game to
No.
be seized?
No, Your Honor, absolutely not. But in this case, I would say that once the police were in the apartment on an unchallenged warrant to search for other objects, they saw that cell phone not just sitting next to the bed in plain view, but they saw it sitting next to a large bag of marijuana in plain view, also being there with probable cause to believe that the crimes of murder and conspiracy, critically, conspiracy to commit murder with two individuals on videotape clearly arriving and immediately leaving from a premeditated killing, then it is certainly reasonable to seize the cell phones in plain view as potential evidence because there is a reasonable probability, a fair probability, which is all that's required, that evidence of a crime would be found on cell phones, given the knowledge.
Why isn't this a general warrant, as the appellant?
Because the only
appellant
warrant
suggests?
that we have on March 5th very specifically describes the place to be searched and the things to be seized. That's why it's not a general warrant. The fact that the affidavit does not include the word cell phone is a red herring. The courts have stated over and over again, there are no magic words that are required in affidavits. It's a common sense, a practical, non-technical question based on common sense conclusions about human behavior. The circumstances that go to evaluate whether an officer acted in good faith frequently include a particular officer's knowledge and experience, including specific uncontroverted facts, which necessarily inform reasonableness, even if they are omitted inadvertently from a warrant application. Any other outcome would produce anomalous results. Evidence might be suppressed when it was obtained pursuant to a warrant supported by the affidavit of an officer, even if the affidavit was deficient, who actually, in fact, possessed probable cause. And that's the situation that we have here.
Okay, thank you.
Thank you,
The
Justices.
matter will be submitted.
Everyone, please rise.